2 years ago, I got a phone call from a woman I'll call Patricia. Patricia wasn't reaching out about her own situation. She was calling on behalf of her elderly mother, a 78-year-old woman named Ruth, who had spent 44 years living in the same home, a home she had fully paid for. No outstanding mortgage, no liens, no financial obligations of any kind tied to it. Ruth had spent the final 3 years of her life receiving care in a nursing facility, with that care funded through Medicaid. The family had handled everything properly. They had submitted the Medicaid application correctly. They had disclosed every required detail honestly. They had complied with every instruction they were given. Ruth passed away quietly and peacefully 6 months before Patricia picked up the phone to call me. And then an envelope showed up in the mail. Not a sympathy note, not a standard piece of government paperwork, but a formal legal notice from the state informing Ruth's family that the government was filing a claim against Ruth's estate, targeting specifically her home, in order to recoup the Medicaid benefits she had used during those 3 years in the nursing facility. The dollar amount the state was demanding, the amount it planned to extract from the home Ruth had lived in for 44 years and had fully paid off, came to $227,000. Patricia was in tears when she called me. She said, "How can this even happen? That was my mother's house. She paid it off herself. She wanted us to have it. The government doesn't have the right to just take it." I had to deliver news that I have had to deliver to far too many families on far too many calls just like that one. The truth is, under federal law, under a program known as the Medicaid Estate Recovery Program, they absolutely can do exactly that. And heading into 2026, with various states updating and expanding their estate recovery regulations to broaden the definition of assets that can be reclaimed, the financial exposure families face is greater than it has ever been before. But here is something else I told Patricia as well. There are legitimate legal strategies, well-documented and time-sensitive strategies that could have shielded Ruth's home from this outcome entirely. Strategies that Ruth's Medicaid advisor never brought up, that the nursing home intake staff never disclosed, that the state Medicaid office certainly never went out of its way to mention. Strategies that genuinely work, but only when you put them in place before Medicaid benefits ever begin, not once benefits are already being paid. In this video, I am going to walk you through everything Patricia should have known before her mother ever stepped foot inside that nursing facility. What the Medicaid Estate Recovery Program actually is, why a fully paid-off home is particularly and significantly more vulnerable than most families ever realize, the 5 legal protections that are available to you right now, and what steps you need to take if you or a loved one owns a paid-off home and there is any realistic chance of needing Medicaid-funded long-term care in the years ahead before the opportunity to act has passed entirely. This video is for every family that has spent decades working hard to pay off their home. Stay with me. Before I walk you through those 5 protections, I need you to fully understand the scope of what the Medicaid Estate Recovery Program actually is, because the overwhelming majority of people have never heard of it. And the families who encounter it for the very first time almost always do so after the moment when something meaningful could have been done about it. Here is the federal legislation that brought this program into existence. In 1993, Congress passed the Omnibus Budget Reconciliation Act, commonly referred to as OBRA 1993. Tucked inside that legislation was a provision mandating that every state in the country create a Medicaid Estate Recovery Program. The mechanics of the program are straightforward. When a Medicaid recipient who received nursing home or long-term care benefits passes away, the state is obligated under federal law to pursue recovery from that person's estate for the cost of the Medicaid benefits they received. The estate encompasses that person's assets at the time of death, and for the vast majority of seniors, The single largest asset sitting in their estate is their home. The program applies specifically to Medicaid recipients who were 55 years of age or older when they received those benefits, which effectively covers nearly every senior who receives Medicaid-funded nursing home care, and it applies regardless of how long the individual owned their home, how thoroughly it was paid off, or what their wishes were regarding leaving the property to their family. Here is a figure that conveys just how serious this program is. According to data from the Kaiser Family Foundation, states collectively recover approximately $700 million each year through Medicaid estate recovery. Every dollar of that money comes directly from the estates of seniors who genuinely believed their homes were protected assets they could leave behind. Most of those seniors had absolutely no knowledge that this program existed. Most of their family members learned about it the exact same way Patricia did, through a letter that showed up after the funeral. Here is the specific reason why 2026 makes this situation more pressing than ever before. A number of states have revised their Medicaid estate recovery regulations this year, widening the definition of a recoverable estate to capture assets that were shielded in certain states in previous years, including particular categories of trusts, joint ownership arrangements, and life estate interests. The window for utilizing protective strategies that were available just last year has gotten noticeably narrower in several states, and the fully paid-off home is the primary target precisely because it holds the most equity, carries the clearest title, and offers the most direct and uncomplicated avenue for the state to pursue recovery. A home that still has a mortgage attached to it has limited recoverable equity. A home that has been completely paid off has its entire value sitting exposed and available to the state's claim. If you or someone you care about owns a paid-off home and there is any possibility that Medicaid-funded long-term care might be needed somewhere down the road, what I am about to share with you is the most critical legal information you will encounter this entire year. Hit the subscribe button right now. This channel exists for the sole purpose of making sure families have this information when they can still use it, not after the letter has already arrived at their door. Now, the 5 protections. Protection number 1, the Irrevocable Medicaid Asset Protection Trust. This is the most thorough and comprehensive protection that exists, and when it is implemented correctly and with adequate time built in, it can fully shield a paid-off home from Medicaid estate recovery. Here is how it functions. An Irrevocable Medicaid Asset Protection Trust, sometimes referred to as a MAPT, is a specialized type of trust into which you transfer legal ownership of your home. Once your home has been placed inside the trust, it is no longer considered legally part of your estate. In the eyes of Medicaid, you are no longer the owner. The trust holds ownership, and assets that are owned by the trust at the time of your passing are generally not subject to a Medicaid estate recovery claim because they fall outside the boundaries of your personal estate. You retain the right to continue living in the home for the remainder of your life through a specific provision written into the trust. Your children or other chosen beneficiaries are designated as the trust's beneficiaries. Your daily life in the home continues exactly as it always has. The only meaningful difference is that the home now exists within a protective legal structure that removes it from Medicaid's reach. Here is the critical timing element that most families fail to account for. Medicaid enforces what is known as a 5-year look-back period. Any transfer of assets, which includes transferring your home into a MAPT, that occurs within 5 years of submitting a Medicaid application is subject to a penalty period during which Medicaid benefits will be withheld. This means the MAPT must be set up at least 5 full years before Medicaid benefits are expected to begin in order to provide complete protection. A family that establishes a MAPT today well before any Medicaid planning becomes an urgent necessity, is in an entirely different and far more secure position than a family that scrambles to set one up after a nursing home admission has already taken place. Ruth's family could have created a MERP a full decade ago. The home would have been completely protected. The $227,000 recovery claim would never have materialized. The typical cost of setting up a MERP through an elder law attorney falls somewhere between $2,000 and $4,000, depending on the state and the specific details of the estate, measured against a potential recovery claim of $200,000 or more. That investment carries one of the clearest and most favorable cost-to-benefit ratios of any legal planning tool available. Protection number 2, the spousal protection exemption. This protection applies exclusively to married seniors, and it is the most immediate and most powerful shield available without requiring any kind of advanced planning whatsoever. Under federal Medicaid law, a home is exempt from state recovery for as long as a surviving spouse continues to reside in it. This is known as the spousal protection exemption. If a Medicaid recipient passes away and their spouse is still alive and continues living in the home, the state is prohibited from pursuing estate recovery against that property during the surviving spouse's lifetime. This protection is absolute and does not require any legal steps to activate. It takes effect automatically by operation of federal law. But here is where things get more complicated and where families routinely make critical errors that end up eliminating this protection entirely. The spousal exemption shields the home only for the duration of the surviving spouse's lifetime. Once the surviving spouse also passes away, the estate recovery clock begins running again. The state can then file a claim against the home to recover the cost of the first spouse's Medicaid benefits, and in many states, the cost of the second spouse's Medicaid benefits as well, if that spouse also received them. The spousal protection is not a permanent fix. It is a window of time, specifically the surviving spouse's lifetime, during which other protective measures can and absolutely should be put in place. A surviving spouse who takes no action during that window simply passes the Medicaid recovery problem along to their children without ever addressing it. The correct approach when invoking the spousal protection exemption is to use that protected window of time to pursue one of the other protections described in this video, ideally the MERP, during the period when recovery is temporarily on hold. When used together in this way, the spousal exemption combined with a properly timed MERP can deliver complete and multi-generational protection for a paid-off family home. Protection number 3, the caregiver child exemption. This protection ranks among the least recognized and most valuable exemptions in all of Medicaid estate recovery law, and it applies to a specific set of circumstances that arises more frequently than most people would expect. Under federal Medicaid rules, a home that is transferred to a child of the Medicaid recipient, where that child actually lived in the home and provided caregiving to the recipient for a minimum of 2 consecutive years immediately before the recipient's move into a nursing facility, and where that caregiving can be demonstrated to have postponed the need for institutionalization, is exempt from Medicaid estate recovery. Stated in plain terms, if an adult child had been living in the family home and provided hands-on care to their parent for at least 2 years before the parent ultimately required nursing home placement, the parent is permitted to transfer the home to that child without triggering the 5-year Medicaid penalty, and that home becomes protected from recovery after the parent's death. This is referred to as the caregiver child exemption, and it comes with 3 distinct requirements that every single one must be satisfied. First, the child must have genuinely resided in the home, not visited on a regular basis, but actually lived there full time. Second, the care provided must have spanned at least 2 continuous years immediately preceding the parent's entry into a nursing facility. Not 2 years at some earlier point in the past, but the 2 years that ran directly up to the moment of institutionalization. Third, the care must be capable of being documented as having delayed the necessity for nursing home placement through medical records, statements from physicians, or other supporting evidence that substantiates the claim that the parent would have required a nursing facility sooner had the child not been providing in-home care. If all 3 of these requirements are satisfied, the transfer of the home to the caregiving child is protected. The home passes to the child, and Medicaid cannot pursue recovery against it. For families in which an adult child has been providing in-home caregiving, this exemption can mean the difference between the family home remaining within the family and the state claiming it. But the documentation must genuinely exist, and the transfer must be carried out properly through an elder law attorney to ensure that every requirement has been properly fulfilled. Protection number 4, the sibling equity exemption. This protection is narrower in scope than the others, but it addresses a specific family situation that is not entirely uncommon. Under federal Medicaid rules, a home cannot be subjected to estate recovery if it is transferred to a sibling of the Medicaid recipient who already holds an equity interest in the property and who had been living in the home for at least 1 year before the Medicaid recipient was moved into a nursing facility. In plain language, if a brother or sister of the senior owns any portion of the family home and had been residing there for at least a full year before the senior entered a nursing facility, that sibling's ownership interest in the home is shielded from estate recovery. Furthermore, the transfer of the senior's share of the home to that sibling can be accomplished without incurring a Medicaid penalty. This exemption is most directly relevant in families where siblings have been living together and sharing a family home, sometimes a property inherited from their own parents, and one of those siblings needs to transition to nursing home care while the other remains living there. The sibling who has maintained residence in the home and who holds an equity stake can receive the nursing home sibling's portion of the home without triggering Medicaid estate recovery. If this scenario applies to your family, even in part, it is well worth having a conversation with an elder law attorney to explore whether and in what way the sibling equity exemption can be used to protect the property. Protection number 5, the hardship waiver process. This final protection is the one that becomes relevant when none of the proactive planning strategies were put in place, and a family now finds itself staring down an active estate recovery claim, exactly the predicament Patricia and her family faced. Every state Medicaid Estate Recovery Program is required by federal law to maintain a hardship waiver process. This process gives the estate or the surviving family members the ability to apply for a waiver or a reduction of the estate recovery claim based on documented evidence of financial hardship. The specific standards for qualifying as a hardship vary from state to state, but federal guidelines spell out several categories of hardship that must be taken into consideration. The home represents the sole income-producing asset of the estate, and pursuing recovery would eliminate that source of income entirely. Recovery would result in the heirs themselves becoming eligible for public assistance. The heir is a dependent family member who has been living in the home and has nowhere else to go, and the value of the estate recovery claim is disproportionately large relative to the total value of the estate. Here is the critical thing to understand about hardship waivers. They are not granted automatically, they are not simple to obtain, and in a significant number of states, the waiver application process receives very little public attention or promotion. States have minimal financial incentive to make it straightforward for families to get recovery claims reduced or eliminated, but these waivers do exist. They have been approved, and an elder law attorney who has real-world experience with the estate recovery process in your particular state can meaningfully improve the likelihood of a successful hardship waiver application. Patricia's family ultimately submitted a hardship waiver application. The state agreed to accept a reduced recovery amount, settling for substantially less than the original $227,000 claim based on the hardship circumstances that were documented and presented. It was not a complete win. Some funds were still recovered by the state, but it was a significantly more favorable result than it would have been had the family simply accepted the original demand without pushing back or seeking help. If you are currently in the middle of a Medicaid estate recovery claim, do not pay it outright and do not simply ignore it. Reach out to an elder law attorney without delay and ask specifically about the hardship waiver process in your state. Let me bring all 5 protections together one final time for clarity. The Irrevocable Medicaid Asset Protection Trust is the most all-encompassing solution available, but it must be established a minimum of 5 years before Medicaid benefits begin. It typically costs between $2,000 and $4,000, measured against a potential recovery claim that could be 10 to 20 times that amount. The spousal protection exemption provides automatic federal protection throughout a surviving spouse's lifetime. Use that protected window to put additional strategies in place. The caregiver child exemption means that if an adult child lived in the home and delivered documented care for 2 years leading up to institutionalization, a penalty-free transfer and a recovery exemption may both be within reach. The sibling equity exemption means that if a sibling owns a share of the home and resided there for at least 1 year before institutionalization, their interest and a transfer of the other sibling's share to them may be fully protected. And the hardship waiver means that if you are already facing an estate recovery claim, the waiver process is available and can result in a reduction or complete elimination of the claim when handled with proper legal guidance. 5 protections. Every single one of them is real. Every single one of them is accessible right now. And not one of them was ever mentioned by the Medicaid office, the nursing home admissions team, or the state agency that will eventually send the recovery letter. Ruth's family could not turn back time. The window for putting protective planning in place had already closed. But Patricia said to me, if we had known any of this 5 years earlier, my mother's home would still belong to our family today. That is precisely the reason this video exists. Share it with every family you know who owns a paid-off home and has a parent approaching the stage in life where long-term care may eventually become necessary. Because the 5-year look-back period means the right time to take action is not when the need for care suddenly appears. The right time to act is right now, a full 5 years before that need ever arrives. The letter Patricia received showed up 6 months after her mother's funeral. The legal strategies that would have prevented it from ever being sent needed to have been in place 5 years before her mother was ever admitted to the nursing home. You now have the knowledge of what those strategies are. Put that knowledge to work before the letter ever arrives at your door. What happens if Medicaid denies a benefit application because of asset transfers made before the 5-year look-back period was properly accounted for? Check out the next video where I walk through exactly how to appeal a Medicaid denial and the specific legal arguments that have successfully overturned those denials in administrative hearings. I will see you over there.